Yeah. Oh, thank you.
Do I see a Chief Justice there in the crowd? It's nice to have at least one Chief Justice in the crowd. Welcome, Chief Justice Ireland and your students. If at any point in time you feel inclined to return to this seat, just give me a
SJC-11496, Commonwealth v. Darkins, Bonnett.
Ms. Belger, good morning. I need you to wait a moment until we're all set and you can get started. And I'm sorry you have this Chief Justice and not that one. But you can dream.
Morning. May it please the court, Amy Belger for Darkins Bonnett. This case is back here following a remand by this court in 2015 for a Roviaro hearing, as the trial judge at the time of trial did not conduct the orderly appraisal that is necessary under Roviaro in determining whether some federal exculpatory evidence could be used by the defense at trial. What happened when the case was remanded was unusual and I think unexpected by everybody, and made analysis of what to do with the evidence difficult. So the case is remanded for a Roviaro hearing to decide whether or not certain federal evidence is going to be disclosed or made available to the defense, except that independent of the Roviaro hearing and analysis, the evidence was obtained by the defense outside of that process. And then what the evidence was, once we learn it, we can't unlearn it. It's highly exculpatory from the view of the defendant in that it is evidence that somebody other than the defendant was the shooter in the
Ms.
case.
Belger, isn't the issue here the fact that the judge is the one who's assessing the credibility of the witnesses at the motion for a new trial? And so we're looking to whether there was an abuse of discretion there?
Well, I don't think that this is a typical newly discovered evidence case because of this Roviaro component to it. And perhaps you look at, you do a newly discovered evidence analysis, but you also look at, does this new evidence create a reasonable doubt that may not have, didn't otherwise exist at the time of trial? So you have to do both.
You never really did the Roviaro, the motion.
I'm sorry,
You
Your
never
Honor?
really did the Roviaro
So,
analysis. And what I wanted to ask about that was, then instead you brought a motion for a new trial.
yes.
And then we decide that on motion for new trial standards that are typical.
So what happens is once the evidence is there, the motion judge did the first prong, if you will, of Roviaro, and found that there was reason to invoke the informant privilege, but that also, the evidence itself was material using the favorable standard or the relaxed standard there to the defense. And then from there, deciding what to do with it, well, we already have it and we already know what it is. So they proceeded with an evidentiary hearing on that evidence.
Can we just,
It was a motion for new trial, though, right? It was on a motion for new trial.
It was, yes, it was. Yes.
excuse me, could we go back to Justice Budd's question, though, because that seems to be what this is all about. Your position is that when Judge Drexler made his decision on the motion for new trial, he was determining the credibility of the witnesses who testified, who would be the witnesses at trial, who would testify to the out-of-court declarant Payne's statement. Now, Judge Drexler, no doubt, in doing that, has to decide whether or not, as a preliminary question of fact, upon which admissibility depends, whether or not the statement against penal interest applies. But he doesn't decide whether or not those witnesses are telling the truth. He's deciding whether a reasonable jury under 104B could decide whether or not Payne is telling the truth, and he didn't do that.
Right.
Isn't that just the core of, it's just the question Justice Budd asked a minute ago. Isn't that the whole thing?
I think it's the whole thing. Because he's not supposed to be analyzing or assessing the credibility of these three people who are testifying. The evidence that is, to be analyzed is the credibility of the statements that Payne made.
Can I press you on that? If a judge is, and I think you're focused on it appropriately so, on would this have impacted a jury, right?
Right.
But to get there, the judge had made a preliminary finding that this evidence wasn't believable, that he didn't credit this. So are you saying that the judge is just a pass-through, that he's supposed to ignore the credibility of the evidence and just say, well, I don't believe a word these witnesses are saying, but if they were allowed to testify, it's going to impact the jury. So what's the role of the judge here?
I'm saying he didn't engage in the proper legal analysis, just like the trial judge didn't engage in the proper legal analysis
so
on
can
the
you state-
Roviaro issue. This motion judge didn't either. And, it is different in terms of, what type of evidence in terms of what happened here in his analysis. When he looks at the three witnesses, what he's supposed to be doing, and, I'm familiar with, I understand the cases about how we assess the credibility of the witnesses, and, that's the motion judge's task in a Rule 30 hearing, but he never put it in the context of the entire case, which is also what he's supposed to be doing. He didn't do that.
I don't
He
get
didn't
it. take
the evidence.
But I don't get it yet. I mean, back to Justice Gaziano and Justice Lowey's questions, and Justice Budd's. Judge Drexler finds they're lying. He's finding all these witnesses are lying, right? He's saying they just made it up, essentially, right?
Except
and that's something he's entitled to do, isn't he?
I would say he is not.
He can't deny the admissibility. I mean, you're relying on an appeals court case, but that's an admissibility issue. That stuff may be admissible, but he can find it not credible, can't he?
He never took that evidence and put it in the context of the whole case. Right. And that's what he's supposed to be doing.
So,
and whether or not from there, there was a real doubt here. And whether it would have made a difference, because you have to put it in the context of what the evidence was against Darkins Bonnett at trial, right? Sheffery Johnson was impeached, and the other witness against my client was a snitch, and that was it. There wasn't any, other evidence. And the ID that Sheffery Johnson makes of my client at trial wouldn't even be admissible if there were a new trial, because she affirmatively said before trial that my client wasn't the shooter and wasn't there. So he's not putting what he's hearing and what he's seeing in context of the evidence in the entire case. That's what he was supposed to do, and he didn't do. And I still do believe that in terms of the type of evidence this is, Brandon Payne being unavailable and it being statements against interest, that analysis under Weichel, that still applies here in terms of what you should be doing.
If there was a murder case and motion for new trial, a mother submits an affidavit and testifies in front of a judge and says, my son's a really good boy. He was with me the entire night. He couldn't have committed that murder. And the judge just says, you know what? She's lying through her teeth. Now, he was with me the entire night. There's a solid alibi. Would impact a jury because he didn't do it. Isn't a judge allowed to say in that instance, good try, but I don't believe the mom, you don't get a new trial?
I think so, except this case is a little bit more.
But that's an assessment of credibility of mom, right?
But maybe if mom is, the statement against interest component of this, I think, is the decisive difference. There's nothing about that you analyze mom's credibility, but when you're talking about...
you're saying that the judge in that instance is able to make a credibility
Yes,
determination?
as to the mother.
Okay.
But when you're talking about somebody testifying against their own interest that they committed the murder, it's a different analysis. It's a different analysis under the rules of evidence.
It gets in, but.
Okay, but let me, can we step back? Because we've got two things going on. We've got a motion for a new trial, and which we're evaluating whether it's an abuse of discretion, correct?
Yes,
But we still have a 33E issue,
we do.
which
and-
means that we need to be making that determination ourselves.
You do. And I think it's a 33E situation that you need to focus on from a number of different perspectives. You know, what happened in terms of the remand and the Roviaro evidence, it's very difficult to go back in time and say, you know, what would have happened in 2012 versus, you know, what happened.
Right, but why
at the
can't we,
hearing.
don't we basically look at this newly discovered evidence and determine whether or not we think it would have been a real factor in the jury's deliberations had the jury heard that testimony?
I think so, but I think also, in fairness to the defendant, you have to consider what the evidence may have looked like in 2012 versus what it looked like in, you know, 2017, because he was denied the opportunity to use the evidence at the time, you know, it was available when he was tried, and he wasn't given access to it. So, you know, over time, memories fade, people's interests in their own self-interests and the situation changes as to these individuals. And, you know, that has to be a factor in it too, because he was prejudiced by not having access to this evidence at the time of his trial.
Maybe Bazell, but certainly not Edwards or Brown.
Well, certainly not Brown, because that didn't come up till after he was convicted, but I'm not so sure about Edwards, because if he were given that Bazell report at the time of trial, Edwards was around, we can assume, because he's around in 2016, 2017, right? And could have been a helpful witness potentially then. And Bonnett wasn't given a chance to pursue that evidence back at the time of trial.
But the idea that Payne was the shooter was hardly a novel concept back at the time of the trial.
There was no evidence the jury heard that Payne was
I
the shooter.
understand, but certainly in investigating the case, the hypothesis that Miss Johnson was lying and that Payne was the shooter, since he was the one who had the beef with the victim, is not exactly major news.
Well, Your Honor, this is evidence that is of a completely different nature on that issue. People actually saying that Brandon Payne was bragging about being the shooter and that he felt bad, that Bonnett, you know, was being held accountable and convicted for a shooting he committed. That is very compelling evidence of a very different nature than Brandon Payne had a beef with the victim at the time
But
of the shooting.
if you get Bazell, you get all of Bazell. And part of
Yes.
Bazell is the defendant said he was the shooter, and Payne felt badly for taking credit for it in a context in which other members of the gang were saying, you're full of nonsense. It was Bonnett who was the shooter, and you're now trying to take some credit for it. And part of him feeling badly, arguably, is that Bonnett did this for him, and now Bonnett's taking the hit. So, I mean, if you take all of that in context, putting aside the issue of whether they're lying, don't you have an issue as to whether or not in context this is really Payne either trying to take credit for something that he really didn't do and feeling badly that a member of his gang did a killing on his behalf and now he's taken the rap for it?
Well, I think what you have maybe is a reasonable doubt that may not otherwise have existed, because that's up for a jury, you know, that's for a fact finder to weigh and evaluate. And it's not just Bazell, who is all over the place. It isn't just Bazell. It's also Edwards and Brown. So if we're talking about if the defendant has this evidence to use to defend himself, would there be a reasonable doubt potentially that did not otherwise exist? And I think the answer to that question is yes.
Along
there
those
is.
lines, should this be a remand because we never got the analysis that we're talking about right now, and there's some fact-finding that had to go into that analysis. Whether or not to believe the out-of-court declarant is the jury's job, right?
Right.
Okay, and whether or not this entire situation created a reasonable doubt that might not otherwise exist, taking into account everything, in the first instance was for the Superior Court judge,
Yes.
and that didn't happen.
It didn't, although under 33E, I think, at this point, when we look at this, and, the analysis was not done right for the second time, and if we just do the analysis, I would say when we do the analysis, it comes out that,
You factor in the judge's findings of credibility in that?
I think he made the wrong findings. He didn't apply the correct legal standard, so I would recommend that you don't, because it wasn't done correctly. But what you think is best is.
I don't get why it's, if the judge finds none of them credible, isn't it just like Justice Gaziano's description of Mom providing an alibi?
No, because he never analyzed it under the evidentiary rule about hearsay and statements against interest. He never looked
Those
at
are
the Payne aspect of it.
He's got to make a decision about whether or not there's a reasonable likelihood that Payne's statement is true, and in doing that, he considers everything, including these witnesses who are testifying.
He never did that.
I know that, but that's what happens, right?
But, and additionally, he never put it in the context of the entire evidentiary record from the trial. And when you do that and you look at Sheffery Johnson, who has at least 3 stories of her own, okay, and is impeached several different ways, and you look at the only other evidence is a snitch, and there's nothing else.
Got the palm print on the gun.
Yeah, you do, except that you do have the palm print on the gun, Your Honor, but that is consistent with this new evidence in the sense that they're saying Brandon Payne shot and killed Vinnie Gaskins and passed the gun
Yeah, I
to
don't know
Darkins
that-
Bonnett
did
to
you
get
get
rid
any
of it. So
confirmation
there's
for
nothing
that?
about that.
But
that
I guess Bazell was supposed to have said that, and then Bazell, when he testified, said, I never said that.
he says, any way you want to argue it, you can find sworn statements by Victor Bazell to support your position. Okay, he did say it at one point, then he unsaid it and backtracked. So it's there, and that's really for a fact finder to figure out at a trial. That's why we have trials. But, if you look at this and you say, okay, what does it really mean in like real world reality sense? All the evidence, if you put this in, there's a really good argument or there's a really good defense that what my client is what's proven in terms of what he did is he is an accessory after the fact. Right. That then becomes, based on the evidentiary record and what we know now, that becomes a viable defense. Okay. And, in terms of, what is the truth of it, that's for a jury to decide, hearing all of the evidence that's admissible. And I submit to you all of this evidence that's come out post-conviction about this, it's admissible evidence that a jury should hear.
But the judge does decide whether, he has to make a determination, a 104A preliminary question, a fact determination, based on all of the evidence, whether there's sufficient corroboration and whether there's a reasonable likelihood that Payne's statement is true. Correct? And that, you agree, never happened.
It never happened. It should have happened. It didn't happen. But I think, here, I would ask you to look at it and say, given everything that's happened and the evidence that's available, and you analyze it yourself, say this would have created a reasonable doubt that may not otherwise exist. It could have. It likely would have. And, again, it's not a typical Rule 30 newly discovered evidence analysis because of this Roviaro point. We would have to go back. He is extremely prejudiced due to the passage of time. All of this should have been available to him in 2012 to work with as he stood trial in this case.
But going back to Justice Gaziano's question earlier, assuming, I gather what you say we should do, putting aside what the judge did, is we should determine whether or not this reasonably may have affected a jury's deliberation. jury's decision with regard to it. But in doing so, taking the Justice Gaziano example, there is some credibility evaluations we're doing as to whether a reasonable jury would arguably credit that to find a reasonable doubt, is there not?
I think that you do that, putting it in the context of what the trial evidence was.
Right.
When you do that.
Certainly in a
Yeah,
case
I
of
think so.
overwhelming evidence,
Yes.
the Justice Gaziano example ain't going to do it, but
Right.
don't we still have to say, would a reasonable jury likely be influenced by the kind of testimony he describes in deciding the case? And if the answer is no, not really, they're not gonna see that as anything other than after the fact self-serving, then we don't order a new trial.
Well, I think that you have to be very careful of the timelines with things, because Bazell is very close in time when he gives his statement, to the police, and this is over long periods of time. The story hasn't changed. It's from 3 different people. Brown is a complete outlier. He's not even in this gang, okay? That is completely different. And you have to look at that, and you have to look at the consistency of what's being said over the passage of time. And, look at that and say, this is not a neat, clean presentation, but it is sort of a real-life way people talk to each other, who they talk to. If you look at who Brandon Payne's disclosing to, supposedly his relationship with these people, I think that matters. And I think that goes to the credibility of it. It at least would give, lay people sitting on a jury, that would give them pause if it's argued to them that way.
So what I hear you saying is that some evaluation of credibility is appropriate, but we must look at it from the eyes of a reasonable jury and not necessarily our own personal.
Yes, I mean, that would be, for him to have a fair adjudication of his guilt in this situation, he needs a new trial where a jury hears all of this and comes to a decision.
Then what role does the motion judge have in this? Any? I'm confused by that. Then the motion judge is just sort of a pass-through?
Well, I think that the motion judge needed to apply the correct legal analysis.
Can
and if
you
he had-
articulate that in a very short statement as to what that would look like?
Yes.
Taking in mind where we're at with credibility.
Yes. So you look at the 3 witnesses, you evaluate what they say Brandon Payne said, you evaluate how, if at all, that's corroborated by anything under the rule. You look at that and you find that it is, because they all corroborate each other, and it's said separately. It also fits with what Sheffery Johnson said was going on at the scene. It also fits with the DNA evidence, okay? And you become satisfied that, the evidence is material. And then from there, you take, you look at these witnesses.
But you've left out the key point, which is we have to give the judge's credibility determination some weight, don't we?
I think when he applies the wrong legal analysis, no, you don't.
The underlying statements would have been admitted at trial, even if these other people are lying.
Right.
That we have to take into account.
Yep.
And that the jury would have to make its own determination on that. But I don't see how the judge erred. Did he say that it wasn't admissible? He doesn't make that determination. He just says that I find all of these people are lying, therefore there's no need to have a new trial here, right?
But he's supposed to put it in the context of the trial evidence, and he didn't do that. And, that's what I would say. He makes these determinations, but you don't do that in a vacuum. That's not what he's supposed to be doing. He's supposed to be placing it in the context of the entire case, in the trial evidence, and that's where he went wrong, and that's what I have
What's
a
your
huge
basis for
problem with.
saying that? What is it? Is there a case that we can look to?
I think it's grace, right? That's a newly discovered evidence. You take it, you put it in the context of the entire evidentiary presentation, not in the light most favorable to the Commonwealth, but what the evidence looked like at trial. You place it in context and you look at it and you evaluate it that way. And I don't see where that happened.
All right, thank you. Mr. O'Sullivan.
Good morning, may it please the court. David O'Sullivan for the Commonwealth. There are fewer principles in our law that are of longer standing or more well settled than the one that says that newly discovered evidence offered in support of a new trial motion, the weight and credibility of that evidence is a matter for the judge who sees and hears those witnesses. If the only obstacle to a defendant upsetting a conviction resting on sufficient evidence was its admissibility or the fact that it was newly discovered, then there would be little point to evidentiary hearings on these motions. In fact, there would be little point to the evidentiary hearing in this case. Every conviction would rest on shifting sands and await the defendant's friends and fellow gang members or the defendant's mother to come forward with evidence that would be admissible at a trial and would be newly discovered under the standards.
Don't we need to hear from the judge or do our own analysis under 33 if there's no remand? The judge, first of all, has to decide, based on everything he's heard, and has a role to play under 104A, whether or not these out-of-court statements of pain would have come in as statements against penal interest, right?
Well, there are several burdens that a defendant carries in connection with a motion for new trial. One is admissibility.
No, I'm just starting there. So that's one thing he has to do, right?
Well, he need not do it if he finds out of the gate that the witnesses who recount these purported statements against penal interests are not credible in their recounting. And there are at least 10 cases that we cite in our brief that support the notion that his credibility determinations out of the gate are ones for him. After all, he's the one who sees and hears these witnesses.
This is not an academic point. So there's a step first. So first he decides whether or not under the case law, looking at corroboration responsibilities and taking into account whether there's a reasonable likelihood that the statement, meaning pain statement's true, whether or not it would be admitted or not. If it wouldn't be admitted with that 104A analysis, then there you go. But if he would have admitted it, if he thinks it would have been admitted, then you go and say, okay, do the credibility determination he did to see whether or not in that context, that statement in the context of all the evidence would have created a reasonable doubt that didn't otherwise exist.
Well, I don't know that there's any support in the case law for a judge having to go through that order. What a judge has to determine is whether it's newly discovered, whether it's admissible, and whether it's credible, but there's nothing that says which determination he or she must make first. In this circumstance, the Commonwealth had argued below, and our arguments contained at page 76 to 79 of the record appendix, that the evidence would not have been admissible. The judge bypassed that argument and assumed it would have been.
Isn't Justice Lowy, I don't want to disagree with Professor Lowy, but it is admissible. Even if these three people are incredible, the declaration against interest is admissible, right? So the judge has to take into account that this stuff would have been admitted, right? I mean,
The judge assumed it was. The judge assumed the testimony was admissible.
So the admissibility is not the issue. It's the fact that the judge decides the credibility of the three is a trump card, essentially, meaning that no jury's going to find any of this believable, even if it's admitted.
Well, I'm not sure I would say it's a trump card, but particularly it's not as if that the judge's credibility determinations in this case seem to be a product of whimsy or caprice on his part. He didn't just say, I disbelieve all of you, full stop. The judge gave several particular reasons as to each particular witness.
But did he ever say, well, okay, because I actually agree with Justice Caffer. I can't imagine this doesn't fall within the statement against penal interest exception, and I think it would clearly be admissible at trial. So does he ever say, I understand it would be admissible, but even if it were admitted, I don't think it creates a reasonable doubt that didn't otherwise exist, because if that happened, then that's it.
Well,
but did he do that?
Well, the judge said he presumed that the evidence was newly discovered. He also seemed to presume, although in less clear terms, that it was admissible.
Did he say that?
The parties had, I believe it's in the decision of the judge accurately states the Grace and Sullivan standards as set forth in Weichel, and he acknowledges that there are multiple burdens that a defendant carries with respect to this. He notes that the defendant spends a lot of time arguing that this would have been admissible. But I think your earlier question to my sister gets at what the heart is, because the defendant's position allies 2 points. They allied the point of admissibility with the point of credibility.
Right.
And the points are separate. The defendant must establish both. The judge assumed the evidence was admissible, and I would say in many cases that's not the defendant's hurdle in these cases. Admissibility is not the toughest burden to establish.
What's the strongest evidence in the record that he actually made a determination that the evidence is admissible? If you don't have it at hand, you can just send us.
I believe in the opening paragraph, after stating, or one of the opening paragraphs of the judge's opinion, after stating the standard, he goes through that, the parties argue about newly discovered, the parties argue about admissibility. And he goes on to discuss the credibility issue, assuming that those standards are met. He said expressly, I assume that the evidence is newly discovered. And then he says, with respect to admissibility, the defendant argues that this is admissible, but he goes on to say that I must judge the credibility of this evidence. He is not a pass-through. And if he is, as I said, every conviction in Massachusetts would rest on shifting sands and await the defendant's friends and compatriots and his mother to come forward with evidence that would upset it, and that we would have to say that, considered in the abstract, could be a real factor in the jury's deliberations.
So I've got a question. Assuming he didn't abuse his discretion in finding that the witnesses were not credible, what is our job under 33E? So we say he didn't abuse his discretion, but what are we supposed to do now with this?
Well, and the question is important, and I think the court's jurisprudence on 33E says very clearly that although it has powers under that, it doesn't sit as a second jury, meaning it doesn't sit as a second fact finder. It doesn't take a second look at the credibility of the evidence. After all, none of the members of this court were in the room while any of these witnesses testified, and none were able to see any of the pieces. I mean, some of their lack of credibility emerges from the page. Obviously, Bazell is among the least credible witnesses I have ever personally seen, and it's clear that his testimony varied not only from what he said to the police in 2016, but also within the same hearing in 2017, from direct to cross to redirect to recross. His answers depended on who was questioning him. So the court can look at that, certainly, and find that the judge's finding that his testimony was not consistent from one day to the next, but it can't see certain things that are not on the written page. And the judge based his finding of lack of credibility not only on things that this court can see on the written page, but that you could only see if you were in the courtroom. Particularly, and I quote, his extremely poor demeanor on the stand, his evasiveness and insincerity. These are things that are the judgment of, have to be the judgment of the judge who saw these witnesses.
Did the judge do the analysis in the context of the trial evidence as a whole?
He did, Your Honor.
Because he was not the trial judge.
Correct.
Judge Whitehead was the trial judge.
Correct. He did, Your Honor. We provided the trial transcripts to him. He had the benefit of extensive memoranda from both sides that described the trial evidence. He also had the trial transcripts. Before and after, he had memoranda from the Commonwealth and the defense describing, from their perspective, the trial evidence and what it showed. And after the fact, that perfectly described from their various perspectives what the evidence at trial was. And the judge makes reference to the fact that in the course of the trial that there was evidence that Brandon Payne had a motive. In fact, our Commonwealth's evidence was that he was arguing with Vincent Gaskins when the defendant stepped forward and shot the victim in the ear. Immediately before that, Sheffrey Johnson had, wishing not for her cousin and her sort of boyfriend to be arguing, whipped Brandon Payne around toward her vehicle, and the pop was heard behind her. So her account seems to exclude Brandon Payne as the perpetrator of the shooting. She was between Brandon Payne and the victim at the time, and the shooting happened behind her.
Hadn't she herself been shot before trial?
That's correct, Your Honor.
Makes her a little bit wary, don't you think?
Well, that was a determination for the jury to make, and it's apparent, I think, that they credited her testimony. But yes, she was shot, and she was in a wheelchair by the time of the trial. And I would submit, and this is an important point, with respect to the evidence and whether the motion for new trial evidence is considered in the context of the trial evidence. Obviously, we have a DNA non-exclusion of the defendant. But what the evidence at the motion for new trial uncovered is the fact that the defendant and Brandon Payne were in the same violent street gang. So the fact that they may have touched the same weapon at some point was unsurprising based on the evidence that was uncovered in the course of that motion for new trial. It's also the fact that that non-exclusion, the probability statistics were quite low. It was 1 in 8 in the African-American population, I believe 1 in 32 in the Caucasian population, 1 in 22 of the Hispanic population. And even if, obviously, as Justice Gantz pointed out, Victor Brazell did not ultimately testify that Brandon Payne ever said that I shot the victim and then passed the weapon to the defendant, Darkins Bonnett. He disclaimed ever having heard that from any source and testified specifically that Brandon Payne had never said that, even though Victor Brazell had said that. That Brandon Payne had said that in his 2016 interview. But by the time of his testimony under oath, he did not stand that up. So that remained as it did back at the stage of the Roviero hearing in 2011, 2012, a matter for the word on the street and pure rumor. And what the defendant would still be stuck with is his palm print and his DNA with infinitesimally low probability statistics that it's anyone but the defendant on what was clearly the murder weapon, which was found yards from the scene. It was a .22, and the bullet taken from the victim's brain was consistent with a .22, and a shell casing found discharged from that weapon was found in the parking lot. So the defendant would still be stuck with that. And what he wouldn't be able to explain through this evidence offered in the connection with the motion for retrial is that presence, because the only evidence that would explain that would be the evidence that was attributed to word on the street in 2011, 2012. 2016, the story evolves and gets much better for the defendant from Victor Brazell after Brandon Payne has died, and the defendant can exculpate his friend while inculpating a dead person. But then ultimately, in 2017, he doesn't even testify that Brandon Payne ever said that he shot and then passed. That evidence is solely attributable, it's an unsourced rumor even today. So that is not even admissible. And what we have that would be potentially admissible would be the statements of these various witnesses, all confederates of the defendant, all members of his gang and or friends of his that he met in prison, saying that Brandon Payne made vague statements of responsibility for the murder. What we don't have is anything that would explain the defendant's palm print and DNA on the murder weapon.
Can I go back to the issue of credibility? When a judge makes, or when we make such a finding, or when we credit a judge's finding, in my experience, there are two kinds of credibility findings. One is, I don't believe them, but I can imagine that other reasonable people might. And the second, which is more of the Justice Gaziano example, I don't think any reasonable person would credit it. Mm-hmm. Don't we need to do the latter as opposed to the former? Well,
this court's, I think any judge worth their salt does the latter. And it's not whether he personally believes the person, but whether any reasonable jury could. And in Justice Gaziano's scenario, I think a judge would properly make the determination that no reasonable jury could. And I think it's an apt example because we have the defendant's own gang members coming forward and saying things long after the trial that, and after the trial evidence is out there, that would fit with the trial evidence that would assist their defendant by inculpating a dead person. I don't think there's any clearer example of bias and motive to fabricate than these
Is
witnesses.
there any cases that make that distinction, that the judge isn't making his own or her own credibility finding, but rather that no reasonable person could make that credibility determination in this context, in a motion for a new trial context?
Well, all the cases basically state the grace standard. Material and credible, and no case that I could locate makes that express determination, or makes that express, says that clearly. But I think that was what the judge did here. What the court has said in many different contexts is that we have a judge here performing the very basic judicial function, which is that of assessing credibility. He is not a pass-through, and he has to perform that gatekeeper role in connection with the credibility of evidence offered as newly discovered. If there are no further questions, I'd rest on my brief.
All right, thank you.
Thank you.